I recently sent a letter to you related to the potential effect of your Fair Credit Reporting Act rulemaking activity related to data brokers' impact on identity verification and know your customer KYC requirements. In the reply that you guys sent back to us, CFPB will not issue a rule that will prevent financial institutions from meeting the requirements of the Bank Secrecy Act. So as you consult with FinCEN and others on the rulemaking, will you be exploring use-related exemptions if financial institutions are using data to comply with the BSA and other identity verification requirements?
Yeah, we haven't proposed a rule yet, but the answer to your question is yes. But to offer a little bit more color, I think the concern we have is not when financial institutions are using that data because they're using it for financial purposes. It's really when others are using it for unknown reasons, potentially for nefarious reasons. Data brokers they are assembling background reports about people. And under the Fair Credit Reporting Act, there are certain limitations that the law provides, and we're just trying to make sure it is keeping up with the times. But the answer to your question is yes.
Okay. So brief outline of the FCRA rulemaking stated that CFPB is considering a proposal to, quote, clarify the extent to which credit header data constitutes a consumer report, which the CFPB notes would likely reduce, perhaps significantly, consumer reporting agencies' ability to sell or otherwise disclose credit header data from their consumer reporting databases without a permissible purpose. So, do you have any idea, like, you can give me a percentage on enforcement actions carried out by FTC or CFPB dealt with, based on improper use of credit header data? I mean, is this a big issue or not?
Well, I think it's more, the credit header is really the short form report. It does have a lot of sensitive information, not as sensitive as the rest. So I think what we're trying to do here is to make sure that the FCRA, which really was restricting how background reports are created, and I've taken a look at how this works in health, education, others. There's different frameworks for each. We're trying to determine what is the right way to make sure there's adequate protection of that. But again, as it relates to detecting fraud, we're hyper attuned to that issue. And when financial institutions are trying to authenticate identity, we want to make sure we're really cognizant of that.
In May, you spoke at a mortgage industry conference and strongly criticized the business practices of companies that are providing services to help originate and close mortgages. It feels as if you guys have reached some conclusions about closing costs before you even opened up the request for information. Where exactly in the federal statutes is CFPB given the authority to set prices for fees in the mortgage closing process? I guess that would be the first question.
So we have a number of laws, including the Real Estate Settlement Procedures Act, that govern some of this, but mortgage lenders around the country have been consistently complaining to the CFPB about getting ripped off when it comes to credit scores and credit reports. The price increases they are facing have been extraordinary, and I think that it is limiting their ability to evaluate all potential applicants. So we are working with them on ways that they can actually obtain this information in a more competitive, cost-efficient way, because ultimately, many consumers will bear this, or the mortgage lenders themselves will bear those costs.
Okay, let me sneak in one more. In the CFPB 2017 arbitration rule, which was repealed by Congress, the Bureau would have required financial institutions to submit arbitration records to the Bureau to publish. Now the Bureau is proposing a rule that is substantially similar. I guess the question would be, why can't the Bureau follow Congress's very clear directive in this area?
We have not proposed a rule that is substantially similar. It's nothing like what was overturned, nothing at all like it. The original one restricted the use of those clauses This is broadly about understanding contract clauses that waive rights. It is nothing alike.
Okay, thank you. I yield back.